Are people really falsely accused of crimes? I'm attorney Danny Izquierdo of the Izquierdo Law Firm, and people are absolutely, positively accused falsely of having committed crimes. False accusations is probably at its highest. It is most common in what we call sex crimes: sexual battery, lewd and lascivious battery, lewd and lascivious molestation. Let me share this quick case story with you. We were recently retained by a gentleman, middle-aged man, sweet as can be, successful businessman, who was being falsely accused of sexual battery by his much younger sister-in-law. It was the sister of his wife. There is a huge age gap. Because the alleged victim was so young, this individual was charged with capital sexual battery. That means he wasn't entitled to a bond. He would have to sit in jail, no bond, until the state decided what to do with the charges. And then we would have to move for an Arthur hearing. And only at that point, if the judge agreed to exercise their discretion, would he have been released. He was easily looking at anywhere between 3 and 6 months just sitting in jail while the state made its decision and an Arthur hearing could be had. Worse than sitting in jail indefinitely while you're facing an accusation is the prospect that this client would have encountered had he actually been convicted of capital sexual battery. Right after this individual's arrested, his wife reaches out to our office. She's referred by somebody that we're involved with in the community, charity, and we're hired. We're immediately on the case at the jail, meeting with this individual. In this particular case, the alleged victim said that our client took advantage of a moment where his wife left the house to go work for Uber, and at that time is when he then molested her and committed the alleged sexual battery. We then interviewed and thoroughly investigated our client's wife. We went as far as obtaining all of her records from Uber, DoorDash, Grubhub, any delivery service you can think of. And we did that so we can not only tell the prosecutor that our client was innocent and the allegations were false, we did that so that we could show her, we could back up our claim, we can provide her the proof. And it's funny because as a defense, we don't really have a burden. The burden is on the prosecution, but it is our obligation. This is our mission to do right by our clients, make sure that their freedom, their future, and their families are preserved and protected. And that's exactly what we did for this client facing very, very serious, albeit false, allegations. And after about 40 days or so, we were able to convince that prosecutor that our client was completely innocent, that the charge was 100% made up and false, and she agreed to not file formal charges against our client. The state announced a no action, that is a dismissal of charges. If you're a criminal defendant, this is the best outcome that you can receive. What a no action means in Florida is that the prosecutor doesn't even want to present a formal charge. They're going to cut their losses. They are dismissing the case. They are taking no further action. The moment the prosecutor did that, our client was able to get out of jail, reunite with his family, and go on with his life. Because of the work we were able to do, he did that without the burden or the worry of facing a life felony. And he did that without having to register as a sex offender or without having a conviction on his record, hindering everything he tries to do in his life. If you are being investigated for a crime, if you are arrested for a crime, if you are accused of committing a crime, and you feel that you are 100% innocent, you 100% need an experienced criminal defense attorney fighting for you, because the prosecutor and the police officer that arrested you doesn't feel that way.